At 11:42 p.m., Ethan Calder was pulled over for a broken taillight. No speeding, no swerving, no alcohol smell. The officer asked a routine question. "Have you had anything to drink tonight?" Trying to be cooperative, Ethan answered, "I had a couple earlier, but I'm fine." That sentence changed everything. The stop became a DUI investigation. Field tests followed, then a breath test, then an arrest. As a lawyer, I hear stories like this every single day. Today, I'm going to show you exactly which words turn a simple stop into a life-altering mistake and how to avoid them. Why traffic stops are psychological traps. A traffic stop feels casual, but legally it is anything but. From the moment emergency lights come on, the encounter is structured to gather information. The driver often thinks the goal is to resolve a minor issue and move on. The officer's goal is to observe, assess, and document. Those two goals quietly conflict. In real life, courts have repeatedly recognized this imbalance. In Berkmeyer v. McCarty, U.S. Supreme Court, 1984, the court explained that traffic stops place drivers in a pressured environment where they are not free to leave, yet are often encouraged to speak freely. That combination creates a psychological trap. People feel compelled to answer questions even when silence would protect them. Most drivers want to appear respectful and cooperative. That instinct works against them. When someone is nervous, their brain fills silence with words. They explain. They guess. They volunteer details that were never asked for. None of that helps them later. Every statement becomes part of the official record, written down long after the tone and context are gone. Officers are trained to ask open-ended questions for a reason. Questions like, "Do you know why I stopped you?" or "Where are you coming from?" are designed to prompt self-incriminating responses. The driver often does the work without realizing it. No threats, no raised voices, just normal conversation that feels harmless in the moment. This is why traffic stops are dangerous in a quiet way. The risk does not come from arguing or being rude. It comes from talking too much while trying to be agreeable. By the time most people realize the stop has shifted, the damage is already done. What turns that pressure into a real legal problem usually begins with a single sentence. One that sounds innocent until it is written into a report. The sentence that turns a stop into an investigation. Most traffic stops change direction because of one sentence that sounds harmless at the time. A common example is some version of, "I only had a couple earlier," or "I'm probably not supposed to say this, but..." Drivers say it to sound honest. Legally, it does the opposite. Real cases show this clearly. In State v. Varnell, Ohio Court of Appeals, 2014, the driver was initially stopped for a minor traffic violation. The officer had no clear signs of impairment. The situation shifted only after the driver admitted to drinking earlier in the evening. That admission alone was enough to justify field sobriety tests, which later supported an arrest. The court upheld it, citing the driver's own words as the trigger. The law does not require officers to ignore volunteered statements. Once a driver admits to alcohol, fatigue, or distraction, the officer has a documented reason to escalate. It does not matter whether the driver believes they are fine. The standard is suspicion, not proof. This is where many people misunderstand fairness. They assume honesty will shorten the stop. In reality, honesty creates a new legal pathway for the officer. The report does not capture tone, intention, or nervous laughter. It captures exact words, written in a way that supports further action. That is why this single sentence matters so much. It converts a routine stop into an investigative stop without any external evidence. Once that line is crossed, the encounter follows a different set of rules. And once drivers realize the situation has changed, they often respond in ways that make it worse rather than safer. How being polite gets misinterpreted as suspicion. Politeness feels like protection during a traffic stop. Drivers nod, explain, apologize, and try to show they have nothing to hide. Unfortunately, those behaviors often appear very differently when reviewed later. Courts regularly defer to officers' interpretations of behavior. In United States v. Arvizu, U.S. Supreme Court, 2002, the court emphasized that officers are allowed to rely on the totality of the circumstances including nervous behavior and unusual responses when forming suspicion. What matters is how actions are perceived, not how they were intended. This creates a serious problem for polite drivers. Over-explaining can sound rehearsed. Apologizing repeatedly can sound anxious. Volunteering extra details can raise questions that did not exist before. None of this requires bad intent from the officer. The legal system allows subjective interpretation. Many people also try to fill silence because silence feels awkward. They answer questions that were never required. They offer timelines, excuses, or background stories. Later, those statements get compared for consistency. Minor differences become inconsistencies on paper. Being calm and respectful still matters, but politeness does not mean talking. Respect is shown through compliance with lawful instructions, not through conversation. This distinction is rarely understood until it's too late. Once polite conversation starts shaping suspicion, the stop quietly moves in a direction most drivers never expected. And the next phase begins with words that can never be taken back. Voluntary statements that officers can use forever. One of the most misunderstood parts of a traffic stop is the idea of voluntary statements. Anything a driver says without being legally required to say can be written down, repeated in court, and used long after the stop ends. There is no rule that limits those words to the moment they were spoken. A clear example appears in Pennsylvania versus Bruder, U.S. Supreme Court, 1988. The court held that roadside questioning during a routine traffic stop does not require Miranda warnings. That means answers given before an arrest are fully admissible, even when the driver believes the conversation is informal. The law treats casual roadside talk as evidence. This surprises many people. They assume rights begin after handcuffs or a formal warning. In reality, most damaging statements happen before that point. A driver explains where they were going, why they were distracted, how tired they feel, or what they consumed earlier. Each detail can later support reasonable suspicion or probable cause. Officers do not need to challenge these statements on the spot. They simply document them. Later, those words appear in reports, affidavits, and testimony. Tone, stress, and context disappear. What remains is a clean sentence attributed to the driver. The danger lies in how permanent those words become. A driver can clarify later, but initial statements often carry more weight. Courts tend to trust contemporaneous notes over after-the-fact explanations. This is why talking freely feels safe in the moment, but creates long-term exposure. Once a statement is made, there's no reset button. And when drivers sense that risk, they often swing to the opposite extreme. Believing silence itself will cause trouble. Why silence feels dangerous but saves you. Silence during a traffic stop feels uncomfortable. Many drivers worry that refusing to answer questions will appear rude, suspicious, or aggressive. That fear pushes people to speak when they would be better protected by saying very little. Legally, silence is allowed. In Heibel versus 6th Judicial District Court of Nevada, U.S. Supreme Court, 2004, the court confirmed that drivers may be required to identify themselves, but they are not required to answer investigatory questions. Beyond basic identification and required documents, most questions are optional. The problem is emotional, not legal. Silence feels like defiance, even when it is calm and respectful. Drivers imagine escalation. They fear consequences that feel immediate. In reality, the law does not permit punishment simply for declining to answer questions. What matters is how silence is used. Silence paired with compliance works. Hand over documents. Follow instructions. A simple phrase such as, "I choose not to answer questions," sets a boundary without confrontation. That boundary protects the driver from creating evidence against themselves. Courts do not treat silence as guilt. They treat statements as evidence. Choosing not to speak preserves options later, when legal advice is available and pressure is gone. Many cases turn on what was said, not on what was withheld. Drivers who speak often provide the missing pieces themselves. Understanding this difference changes how a stop unfolds. Because once silence is understood, the focus shifts to the exact moment when a stop quietly changes its purpose. the moment a stop stops being about the violation. Most drivers believe a traffic stop stays focused on the original reason: speeding, a light out, rolling through a sign. Legally, that focus can change very quickly. The shift happens the moment an officer develops what the law calls reasonable suspicion of something more. Courts have consistently allowed this expansion. In Rodriguez versus United States, U.S. Supreme Court, 2015, the court explained that a traffic stop may last only as long as needed to address the traffic violation unless new reasonable suspicion arises. Once it does, the stop can lawfully turn into something else. That suspicion can come from observations or from the driver's own words. This is where people get caught off guard. A casual comment about being tired, distracted, late, or having a drink earlier can justify further questioning. The officer does not need certainty. The legal threshold is low. The report only needs to show a reasonable basis to continue. Drivers often sense this shift but misread it. They notice more questions. The officer's tone changes. Backup may arrive. At that point, many people try to talk their way back to the original issue. That rarely works. Once the purpose of the stop expands, it does not shrink again. Courts generally defer to the officer's judgment at this stage. In United States versus Sharp, 1985, the Supreme Court stated that courts should avoid second-guessing officers' on-the-spot decisions when reasonable suspicion exists. That deference gives officers wide latitude. The critical mistake is assuming cooperation can reverse the process. It cannot. Once suspicion is documented, everything afterward is viewed through that lens. Recognizing when this shift occurs is essential because what follows depends entirely on how the driver responds next. What to say, what to refuse, and when to stop talking. Once a stop reaches this stage, clarity matters more than friendliness. The law draws a firm line between required compliance and optional conversation. Knowing that line protects drivers from making the situation worse. Drivers are required to provide identification, registration, and proof of insurance. That obligation is clear. In Delaware versus Prowse, 1979, the Supreme Court reaffirmed the state's authority to request these documents during a lawful stop. Refusing at this stage creates separate problems. What drivers are not required to do is answer investigative questions. Questions about where you were going, what you were doing, or whether you consumed anything are generally optional. Courts have upheld the right to decline politely. The key is how it is done. Simple language works best. I choose not to answer questions, or I would like to remain silent, are clear and non-confrontational. These phrases establish a boundary without escalating the encounter. They also create a clean record if the interaction is later reviewed. It is important to stop talking once that boundary is set. Many people undermine themselves by continuing to explain after asserting silence. Partial silence does not protect anyone. Consistency does. Real cases show how powerful this can be. In Salinas versus Texas, 2013, the Supreme Court highlighted how unclear silence can still be used against a person. Clear, verbal invocation matters. Ambiguity favors the record, not the driver. None of this requires hostility. Calm tone, steady behavior, and compliance with instructions go a long way. Respect is shown through actions, not words. Traffic stops rarely ruin lives because of the violation itself. They do so because of what is said afterward. And understanding that difference changes everything about how these encounters end. Outro. A traffic stop rarely starts as a serious problem. Most of the damage happens after the lights come on, when stress takes over and words come out faster than thought. Every case discussed today follows the same pattern. A small stop, an unnecessary sentence, and consequences that last far longer than the violation ever would. This video is not about being difficult or disrespectful. It is about understanding how the system actually works, not how people assume it works. Silence, clarity, and restraint protect you when politeness and explanations do not. If this helped you see traffic stops differently, share it with someone who drives. Most people learn these lessons too late. Subscribe for more clear, practical breakdowns of how everyday legal situations really unfold and stay informed before a single sentence costs you far more than you expect.